We might be reaching the record, by the way, of the most true questions we've had so far in this courtroom.
That's what we were just saying.
I've never seen it in any of my trials, Your Honor.
Okay, come on up. We do actually get a lot of questions in here, but I don't think we've ever had this many. We usually just get like 1 or 2 from a jury.
I think one numerous times, I've never seen. Plan.
Just to
Stephanie Zinna for defendant Zaon.
Okay. So let's talk, do council have agreement, I'm sorry, I haven't had a chance to look at any filings yet this morning. Do council have agreement as to, or have council all had a chance to review the potential verdict form if this case goes to punitives?
Yes, Your Honor, we agree with that.
Yes, Your Honor, the verdict form's fine.
Okay, and then I do see that I got additional instructions filed, today, just a few minutes ago, thank you. Just one additional instruction, or 2? No, 1. Just the one, evidence of future earning capacity may be considered when determining the defendant's financial condition for the purposes of evaluating a punitive damages award. Is there stipulation to that or not agreement?
No, not agreed.
Okay,
And I had filed 3, or I had emailed 3, but I have a copy if you'd like.
emailed?
Email.
Okay, yes. Does opposing counsel have a copy?
Yes.
Okay, then yes, please bring me a copy. Or please hold me for the copy. Thank you. Okay. So what I'm holding in front of me are 3 instructions, and I'm gonna print the instruction from Okay, but I'm holding on 3 instructions from defendant. The first one starts with, you have now found that plaintiffs suffered damages as approximate. Should we change it to legal?
Yes, and I am sorry, I did not catch that. Yeah, I took 12.1 and modified it a bit here.
Okay. So, thank you very much. So you have now found that plaintiffs suffered damages as a legal result of defendant Zaon Collins' conduct, and that defendant Zaon Collins is liable based on that conduct. Plaintiff, what is your objection to this instruction?
May I ask defense counsel what she modified?
I reworded it so because the intro is, if you find that plaintiff suffered damage as a result of the conduct, and if you find that they are liable, it's just the instruction that we give before they check the punitive damages box. So I just altered that wording to say that if they check that box, you have now found that this, because they're not considering that.
Was nothing else modified?
Nothing else was modified except to take out the other definitions of fraud and the other punitive damages words.
Shouldn't this be a little bit revised because they've already found that it should be awarded, so now they just have to decide an amount?
Right, that's what I was trying to do, was just modify it to, they still need this instruction, but just try to modify it to update it.
Well, I think the second paragraph is out, Your Honor, because they've already found by clear and convincing evidence that defendant Zaon Collins was guilty.
Hold on one second. Okay, the last one we had to use punitives, do you remember any parties without saying them out loud right now? I want to pull that instruction that we read. Because we did read an instruction, and it was already drafted, and it might be better than rebuilding the wheel here. I remember one of the parties' names was Eris. Oh, okay, I'll find it.
I believe so.
Give me just a second. We have another case where I think I have it.
Yeah.
Don't say anything else out loud, sorry.
I'll look at you for what I remember.
It was like a weird spelling in the first name, which I think I just did right. Yeah, I got it. All of them get filed, right? Everything that we read to them. So I've got another case where we did go to punitives. Let me just pull the instruction that was read, because that might be easier than this one. Here is this case. Let me find the instruction here.
Looking at it right now.
Oh, you got it? Okay. The case or the instruction?
No, the case.
Okay, that's okay too. Let's see it. Okay, maybe we don't have one.
My issue with this one, Your Honor, is I don't believe we need the second paragraph now, that if they've already checked the yes box for punitives, then they've already found by clear and convincing evidence.
Well, I'm also not sure if we need the second sentence.
I think I
Okay. You can.
Agreed. Agreed. It would make sense for second sentence to come out and then second paragraph to come out.
Like, I think it should probably read as follows. You've now found that plaintiff suffered damage as a legal result of defendant Zaon Collins' conduct, and that defendant Zaon Collins is liable based on that conduct. But it doesn't say anything about punitive or exemplary damages. No, this isn't correct. We give them another instruction when they came back for the amount to award. There was another instruction read to them. It wouldn't be in the regular instructions.
Oh, okay.
It was like an additional instruction read later.
Let me see.
Okay, so this should probably read something more effective. You have now found that plaintiff suffered damages as a legal result of defendant Zaon Collins' conduct, and that defendant Zaon Collins is liable based on that conduct. You have awarded punitive and exemplary damages. Punitive and exemplary damages are to make an example or punish wrongful conduct. And then the law provides no fixed standard as to the amounts of punitive damage, but leaves the amount to the jury's sound discretion, exercised without passion or prejudice. And arriving at any award of punitive damage, you're to consider the following. And everything goes through that. Do council understand what I'm saying?
I do, I'm in agreement with it, Your Honor.
So it would,
I would still want the sentence that says punitive or exemplary damages are to make an example or to punish wrongful conduct.
yeah, that sentence would still be there. The second sentence would come out and be replaced with, you have awarded punitive damages. Punitive damages are exemplary damages. Punitive or exemplary damages are to make an example of or punish wrongful conduct.
Oh, I found it.
And then we would skip down to the law.
I think it would,
Agreed.
instead of you have awarded punitive damages, you have decided punitive damages should be awarded.
That's probably appropriate, yes.
Fine with that.
I think maybe this is the one that, but I don't. No, that's.
No, this is too long. It's okay. It's fine. We're rewriting this one. Thank you very much, Helen. Okay, so this would read as follows then. You have now found that plaintiffs suffered damages as a legal, or you have found maybe. I don't know if we need the now. You have found that plaintiffs suffered damages as a legal result of defendant Zaon Collins' conduct, and that defendant Zaon Collins is liable based on that conduct. You have decided punitive damages should be awarded, right?
Yes.
Right.
So that's a new sentence. You have decided punitive damages should be awarded. Punitive damages, maybe we don't even put or exemplary, or do you want to put or exemplary?
I'd rather keep the stock language.
Yeah,
Okay.
punitive or exemplary.
Punitive or exemplary damages are to make an example of or punish wrongful conduct. I don't think the next paragraph makes sense now. I don't think the next paragraph after that makes sense now. So we would start again with, the law provides no fixed standard as to the amount of such punitive damages, and then leave everything else from there down the same.
Agreed by plaintiff, Your Honor.
Agreed.
Okay. And we change the first line as follows. You have found that plaintiff suffered damages as a legal result. So take out the now and proximate becomes legal, right?
Agreed.
Okay. So everybody's fine with that instruction?
Yes, Your Honor.
Yes.
Okay. With the amendments, obviously. And then the purpose of punitive damages are punish a wrongdoer that hereby harms the plaintiff and deter similar conduct in future, not to make the plaintiff whole for their injuries. Consequently, a plaintiff is never entitled to punitive damages as a matter of right, and whether to award punitive damages against the defendant is entirely within your discretion. Okay, did we already give this one?
Yes, Your Honor.
We gave, and then here.
Sorry.
I think, well, even if we gave some version of this, I think it bears repeating in the punitive damages space to make them understand that what the purpose of these damages are.
It was in 37, Judge, with the statute on the THC as well. It was the second part of it.
Okay, this full, like word for word?
Yes. Do you have 37?
I think it does say a plaintiff is never entitled to.
Yeah, and we requested that second sentence be removed for the same reason that Your Honor ruled us the previous instruction. Jury's already determined, if we reach this part, that there's an award should be issued, but that discretionary language
What
applies to the
is
decision.
defendant's position with taking out the second sentence?
What about modifying the second sentence to say, consequently, a plaintiff is never entitled to punitive damages as a matter of right, and the amount of an award of punitive damages against the defendant is entirely within your discretion.
I'm not sure that's, I don't know if that's wrong, but it's not necessarily the law, it's not in the instruction. I think that it's discretionary by virtue of the fact that they're deciding it.
Okay, your position is that they've already determined it's a matter of right awarded in this case?
Correct, Your Honor.
Well, whether it's a matter of right, that it's something that they determined is appropriate for this case.
Okay. How about taking the second sentence and just making it punitive damages against the defendant is entirely within your discretion? Anybody have a problem with that? Like we take out the consequently, a plaintiff is never entitled to punitive damages as a matter of right and whether to award, because they've already chosen to award.
I think we would request that it say the amount of punitive damages is entirely within your discretion. Because since they've already chosen to award it, I think it's the amount that's in their discretion now, not whether or not to award it.
Okay, so if the last sentence reads, the amount of punitive damages you award against the defendant is entirely within your discretion.
Correct.
And then there's no objection to it?
Well, I stand by my original objection, but yes, that language is.
So the purpose of punitive damages are to punish a wrongdoer that hereby harms the plaintiff and deter similar conduct in the future, not to make plaintiffs whole for their injuries. First sentence, no changes. Second sentence, the amount of punitive damages you award against the defendant is entirely within your discretion?
Correct.
Okay, so then that one's done. And the last one proposed by defendant, punitive damages are meant to deter the defendant from repeating his misconduct. What is plaintiff's objection to this one?
Yeah, we disagree with this entire instruction. I think the first part, I think the case law indicates it's not just to deter the defendant, it's also to deter others. So I think this is a misstatement of the law, because it doesn't include the full extent of the deterrence effect and the purpose of the deterrence. Not just to deter the defendant, but for others as well in the community.
How much of this is the form? Nothing? Because it's only cases cited.
Right, all Nevada cases, Your Honor.
And the second case cited, Judge, talks about the amount of punitive damages assessed should be sufficient to punish a wrongdoer and deter others from acting in a similar manner. That's the Ace Truck and Equipment Rentals, Inc. versus Con, 103 Nevada 503. And
Just a
referencing.
second to try to find the, it's all in section 12, isn't it? But I think there's only a few in section 12, aren't they?
Yeah, there's only 3, I think, in there.
Right down to 12.1. 12.2 doesn't apply. How does 12.3, or the version of 12.3 we're putting in, which I believe the one we just discussed comes out of 12.3, although it's not word for word 12.3. How is this one and that one treated? Is the financial position?
Well, I think defendant's position is that the jury needs to understand that while, the jury needs to understand via instruction that punitive damages are not intended and may not financially destroy an individual. I think that's very important for them to hear, especially in light of the damages sought by plaintiff. They need to understand that punitive damages are tied to the financial position of the defendant.
Well, do you know what you're asking for if they come back with punitives? Maybe they're not asking for something that's.
I don't know, it's gonna be tethered to what they awarded in compensatory, Your Honor.
Judge, can we address the law that's cited regarding the financial annihilation or instruction
Yeah.
language? So this concept of financial annihilation, it's one that's pretty, it's played out pretty extensively in the case law. In the third case that's cited, Evans versus Dean Witter, I'm sorry. So some of these cases cite, talk about that financial annihilation concept. Those cases were then abrogated by another case that's cited in here, which is this Ace Truck and Equipment Rental versus Con. And in the Ace Truck decision, which is from 1987, the Supreme Court talks about, they say the financial annihilation rule is necessarily very restricted in its application because punitive excessiveness must ordinarily and usually fall short of total annihilation of the defendant. They go on though to talk about how of late these rules of annihilation, conscience, and passion have fallen into disuse. And they talk about the court basically adopts a new standard. And they say, based on the foregoing considerations, we declare the following standard for evaluating excessiveness of punitive damages. Punitive damages are legally excessive when the amount of damages awarded is clearly disproportionate, clearly in italics, disproportionate to the degree of blameworthiness and harmfulness inherent in the oppressive, fraudulent, or malicious misconduct of the tortfeasor under the circumstances of a given case. If the awarding jury or judge assesses more punitive damages than is reasonably necessary and fairly deserved in order to punish the offender and deter others from similar conduct, then the award must be set aside as excessive. And it states that this rule makes it unnecessary for a reviewing court to make findings or judgments on basically factual questions of financial annihilation or the supposed passion or prejudice indulged in by the fact finder, and permits the reviewing court to focus on a judicial determination of what is fair, just, and reasonable, as opposed to being disproportionate or legally excessive. And this is the concept of what is fair and just and reasonable is a sense that most of us possess from childhood. So we would submit that that is the more appropriate standard. If instruction is needed along these lines, then the language should be crafted from what I just read, and these financial annihilation or destruction language should not be used because it's more or less been set aside, it appears, by the Nevada Supreme Court.
And I believe that's a standard to review the punitive damages award after the fact. It's not guidance that should be given to the jury when they're deciding what to award, Your Honor.
Well, okay. 42005 does actually put legal limits on compensatory damages, or sorry, punitive damages can't be more than 3 times the compensatory damages. So I am a little bit concerned to give them this instruction.
So,
Let me go look at some of these cases. Go ahead, counsel.
and I think Mr. Ladah actually made the point aptly. The case is stating that the court, in assessing what the punitive damages award has been returned by the jury as in an effort to either modify or reduce it, the court is instructed to look at different things than the jury. However, I think the case law stands that the jury is instructed and needs to be instructed that punitive damages need to be tailored to a defendant's financial position. Otherwise, what is the point of introducing the financial condition of the defendant? Why are they hearing this evidence as to his financial condition if it is, and why it is relevant? They need to be instructed on the law for that. Not only that, but the statutory limitation on punitive damages in a case where they have requested a $35 million award of compensatory damages, if it's limited to 3 times that, $100 million would be the end cap. So I don't know if there's maybe 5% of people in the entire population of the world that could potentially pay that. And Zaon Collins is certainly not one of them.
Your Honor, can I respond?
Yeah.
Okay, so the stock instruction that we've already agreed on actually talks about the financial condition. Subsection 2 says the amount of punitive damages which will serve the purposes of punishment and deterrence, taking into account the defendant's financial condition. So it actually says the law appropriately that they can take into account
Well,
the
you're
defense.
both, I'm assuming that defense instruction number 3 and plaintiff instruction, proposed instruction, these are the competing instructions, right? And I'm holding up the one that was filed by Ladah Law Office today and the one that was filed by, or the one that was handed to me by defense counsel today as well. I'm assuming these are competing instructions. Your instruction that you want is just evidence of future earning capacity may be considered when determining the defendant's financial condition for purposes of evaluating a punitive damages award. And defense wants this full instruction that goes through these 2 paragraphs, right? I'm correct that these are competing instructions, right?
I don't know if they're intended to be competing instructions on that particular issue. But we submit that instruction 3 is appropriate, and if we need to maybe adjust some language. But I think the jury does need to hear that the wealth and financial situation of the defendant is relevant, and the award cannot be more, you cannot essentially just financially destroy somebody for the rest of their life for a punitive damages award.
And can I finish my record? I'm sorry, Your Honor.
Yeah, go ahead.
Okay, this is not a correct statement of law. If this is given to the jury, they will be misinstructed in the law. The annihilation language has been eliminated from the law. It is not appropriate. Second of all, this instruction does not talk about deterring others. That's a very important aspect of punitive damages, not just deterring the defendant from the conduct, but deterring others in the community. That's clearly stated in the law, numerous places by the Nevada Supreme Court in good law. It has not been overruled, Your Honor. So this, as stated, if this is given to the jury, this is an inaccurate statement of
Okay,
the law.
you have these other 2 instructions though. These other 2 instructions are gonna be read to the jury if they click yes on the punitive box. okay, with the changes that we just talked about. So we have deterring future conduct already in one of these instructions, okay? And the second one, deter similar conduct in the future. We also have taking into account the defendant's financial condition in the first instruction here. So I just need to determine what of these two instructions actually needs to be included, if anything, in addition to these two.
I'm sorry, I don't know if we decided on the second sentence of the second instruction, defendant's proposed instruction number 2.
I thought we did.
I
I'm going to
thought,
read the whole thing to you
yes.
as I think it's, do you have these in Word? Maybe I
Oh,
just,
within the discretion, I apologize, Your Honor, you're correct.
okay.
What-
So, I mean, I will make copies of these so that everybody can see what I believe the changes to be. And if they're not consistent with what you guys believe the changes to be, that's fine, but I am a little bit, I'm not a little bit, I think that what some of the issues you guys are already bringing up are already in these two. And I don't wanna litter them with additional instructions that are saying the same thing when they come back. They're probably already gonna be mad enough that they're back, okay? So, I think we should make this short. And I'm not confident that these two instructions alone don't satisfy the concerns that everybody has.
Judge, our position with respect to the instruction we submitted this morning is very nuanced to the issue of future earning capacity, and we do not believe that that is sufficiently included within the instruction that we've all agreed to, which does reference financial condition.
Doesn't financial condition encompass future earning capacity when we just say financial condition?
It may to
She's not
some.
gonna be able to get up and say, future earning capacity doesn't factor in here. When you are gonna put him on the stand, you're gonna ask him about future earning capacity, I imagine,
Yes,
Your Honor.
right? Are you?
I think so in this particular case, and this is why I do not believe future earning capacity would apply in this case, is because he's a junior in college and does not have a future earning capacity. So what I was expecting from plaintiffs is they're going to get up and say, well, he's gonna go to the NBA, he's gonna go do this, and he's gonna make millions of dollars one day, when that's just simply not the case. He's a college kid, he's got no prospects, he's got no job, he's got no income, he's got no contracts, he's got nothing. So for them to be able to then speculate, okay, well, he's a good basketball player, he could go and make all this money playing basketball, does not comport with the law that they have cited here and would not apply to this particular defendant. It would be very extraordinarily speculative for them to argue that, well, he might be a really good basketball player. And in fact, the evidence, the case that they cite talks about evidence of the defendant's current employment and ongoing potential income from that employment, which would be relevant. He doesn't have employment, he doesn't have income to talk about his future earning capacity. He's in college, he doesn't, what if he doesn't get a degree, we don't know what his job is.
Okay, I imagine that they're gonna put him on the stand and ask him about nil money, potentially, right?
They didn't do any discovery on it, so I don't know, Your Honor.
Okay, I imagine they're gonna put him on the stand and ask him about all this. So we're talking about two different things right now. You're trying to preclude them from speculating. They're not gonna be allowed to speculate. They're gonna have to put him on the stand and ask him questions, and he's gonna give answers to those questions. And then they're gonna be able to use those answers in whatever additional closing argument that you guys both give regarding the punitive damages. Are we all on the same page with that?
I believe so, Your Honor.
I believe so with the extent of, and I was gonna make a record after this, that they did not do any punitive damages discovery during this case, so they don't have, I don't know what they're intending to ask him even.
I'm gonna get into his, he has
Does
a
your
full-
client have it's your client that would have the information, so
We
it's not like
provided
they're
an
going.
affidavit of no assets and no insurance.
Okay,
That's all
so
that we,
have they received that?
they should have, it was very early in the case.
Okay, so they'll be able to ask your client on the stand, because I imagine your client knows about that, he signed it, right?
He signed it.
Okay, and then, like I said, you'll be able to ask about whatever other stuff you're gonna ask about. We're not disclosing new witnesses right now, okay? At least not, everybody's informed everybody, we're just putting Zaon on the stand?
That's my understanding.
Okay,
Correct.
so,
And she hasn't told me about any other witnesses. My understanding is she was gonna tell me by 9 AM. So
are there any additional witnesses?
Not at this time.
Okay,
And it, I mean,
So-
but it depends on,
at this time, I'm not inclined to permit these additional instructions because I don't think they're needed. I think with the instructions we have, with the revisions to them are fine. Ms. Zinna, since these were your instructions, can you make the changes that we discussed and send them over to opposing counsel? I'm gonna go make copies of these right now, so you guys know what I think the changes are. And unless you guys jointly agree to different changes, this is what I understand the additional instructions will be.
yes,
Clear?
I can do that.
Okay, so here's my thought. If they come back and they say yes to the punitives, I think the best thing to do is to give you guys a couple minutes to regroup. Well, I imagine you'll first want us to ask if it's all their verdict. I'll ask if anybody wants to pull the jury, we'll poll them. We'll see what the next steps are, and when this thing goes to a punitive phase, if the answer is yes, we'll give them, I'll give them a 15-minute break to go get coffee or stretch their legs while you guys regroup. Is Zaon able to come here within like half an hour notice? Is he gonna come
Oh,
for
yeah.
the reading of the verdict?
Oh, yeah.
Okay, so if he's already here for the reading of the verdict, we'll take that 15-20-minute break, and then we'll just get started going again. The only caveat or maybe hiccup is if the court has a hearing, I'll have to either figure out how to shuffle the hearing, or I'll conduct a hearing. But the only hearing I have left today is a very quick one this afternoon that, check, make sure. Actually, it's a proof of hearing for a default judgment. So those are usually 15 to 20 minutes tops. But if this is going, I will reschedule that if they come back before then. These will be ready and you can send them over to opposing counsel how soon?
I texted my assistant to get that done right now.
The verdict form I understand is this. I will copy that with this for everybody right now. Anything else that anybody wants to review at this time? We'll make a record of it this time.
I don't believe so, Your Honor.
Not this time, no.
Okay, we're gonna just pause for 1 minute while I go make copies of these. I'll be right back, give it to you, and then we'll go off if everybody still has none.
Are we off the record?
Not while the lights are on.
Okay.
As soon as the lights go off, we are. Okay, I'll be right back. Okay, we are back on the record in case A 21844652, C, we are outside the presence of the jury. I'm gonna just hand counsel everybody's gonna get 2 copies. There's no difference with the blue and the white, it's simply just so I knew that I was giving everybody 2 copies. That's what I understand the revised instructions to be, as well as the proposed verdict form for the punitive phase. Can counsel just take a look at them and confirm that that's what they understand they are too?
Yes, Your Honor.
I think my only change on the 12.1 is that I believe we stated you have decided punitive or exemplary damages should be awarded instead of just punitive.
That, I don't have any problem with that. That's totally, I don't think that changes any of the meaning. You guys okay with that too? You understand what she's saying?
Yes, Your Honor.
And if you can't read my handwriting, I apologize in advance, but I think you guys all took notes as well. I just want to make sure we were all on the same page before,
And my only request on instruction number 2 is after it says, and deter similar conduct in the future, put in the words, from the defendant and others in the community.
I would object to that language, it's not in 12.3.
I think it's consistent with the case law, Your Honor.
I'm hesitant to deviate further from 12.3 and deter similar conduct in the future is right out of the I believe this is right out of the bottom of 12.3. The purpose of punitive damages are to punish a wrongdoer that hereby harms the plaintiff and deter similar conduct in the future, not to make the plaintiffs whole for their injuries. The amount of punitive damages you award against the defendant is entirely within your discretion. So I'm gonna leave it as is. I understand your argument, but at this time, we're gonna leave it as is with the language. Anything else from anybody?
I won't be precluded from making that argument, though, to the jury.
I would object to that
Because
argument.
It's consistent with the law, Your
You
Honor.
wanna make the argument, repeat what you want me to do? 'Cause I'm gonna
Say
go,
their purpose is to deter conduct from the defendant and others in the community. I think it's consistent with the law, Your Honor.
have a site ready when she objects,
Okay.
and I'll make a ruling on it, okay?
So thank you.
I'm not gonna like a preliminary ruling right now, because I'm gonna go look up the additional cases that you guys cited in this motion. I mean, excuse me, on these instructions, because I think they're probably gonna become an issue when you guys do your argument, and so I wanna make sure I'm sharp on the cases too, depending on what time we end up doing this, because I think we could be doing this as early as this afternoon.
Thank you.
Okay, anything else from anybody at this time?
No, Your Honor.
Okay, thank you guys for coming back. We will call you as soon as we have a verdict.
Thank you, Your Honor.
Thanks, Judge.
Yeah. We are back on the record for page 6, Anna Marie Echevarria versus Zaon Collins, A 844-652. We do have a question from the jury. We are outside the presence. Can I just have counsel, please, for the record, just put their names on the record.
Ramzy, Ladah, plaintiff.
Joseph Chu for the plaintiffs.
Stephanie Zinna and Paterno Gerani for Zaon Collins.
Brad Johnson and Tyler Watson on behalf of Marvin, excuse me.
So here's the question from the juror. What exhibit number shows the crash video itself? Question mark. We can't find it. And then it's signed, and I'm not making a joke, floor person.
What floor person?
You guys can all come up and see it if you
I
would
just didn't
like.
make sure I heard it.
That's exactly what it says. It says floor person.
And did we determine that's exhibit 12?
It is exhibit 12.
Okay, so I can bring them in here and can read to them and say them, or if you guys are okay with me just writing exhibit 12 on here, am I allowed to give this back to them? No.
Type it out.
Okay, we can type back out exhibit 12. I'll have Kimberly, we'll type it up right now. We'll print it, we'll show it to you guys. And if there is no objection, we will give it to them. Go ahead, Mr. Chu.
So there's no issue with them being able to play the videos?
If you want to hang out, just in case, it might not be a bad idea to just take a seat in the back while I
Okay.
do the default judgment hearing that's on at 1:30 today. And then if there is a second question with that and they come out and ask, we can answer it right away.
Okay, yeah, that's fine. That was just our understanding for whatever reason, but yeah,
Can we test to make sure exhibit 12 will play? Or do you know?
No,
No, okay.
they, it's back there with them, right?
The laptop is back there with them.
Okay, so if they come out and ask,
We have the laptop. that
Marshall went and got the
brought.
laptop because that's why we thought there was an issue with them playing it. We were trying to actually play.
the marshal gave you the laptop out of the room.
Yes. We didn't ask for it. He said,
When we came through security and just now, he asked.
And you've all seen it though, right? You've seen it too? Like, did you take a look at the laptop? There doesn't appear to be anything else on it, right?
Yeah, but I
Have at it.
will.
yeah, feel free.
Take a look, have
Yeah,
at
I
it,
mean-
yes.
So the only issue was,
Sorry.
sorry. I almost
It
stepped
should
on
be
it.
teed up where they just have to hit play, right?
We just plugged in the CD player is all we did.
Well, but we have to use a CD that's back there in that book.
Yeah,
So we'll
okay,
take,
so
we'll-
take that out
Right.
and then, yeah, and then whatever, I don't think you guys put anything.
Okay, so not to throw too many things at you, but
little mess.
Kim just typed up the video in question is admitted exhibit 12. And I'm signing it, Judge Anna Albertson. Anybody have a
Yes.
problem with that note?
No,
No, Your Honor.
no objection,
Okay.
plaintiff, Your Honor. So we gotta
So-
take the. Stan, we gotta take
That will be the note that goes back with them.
And I could take the.
So the videos are not loaded.
No.
Okay, so now we've
You
just.
can put
plugged
it on top of the laptop and hand it to them. There's no objection with them getting that laptop as is, right? Do you want to take a look at it?
I already did.
Do you wanna
Okay.
bring it to you, Your Honor, or what?
Bring it
With the
to
CD player?
Kim. We'll put the note on top and
I can't reach.
Sorry.
Like I got little arms, you gotta. And then I'll go take this back to them.
Okay, anything else at this time from plaintiff's counsel?
No, Your Honor.
Anything else from defense counsel, Zinna?
No, Your Honor.
Anything else from defense counsel, Johnson?
No, Your Honor.
Okay, thank you guys. We will go off on this case. Okay, so we are back on the record in case A 21844652C. Anna Maria Echevarria versus Zaon Collins. I am outside the presence of the jury, but we do have counsel here. Can counsel just put their name on the record?
Ramzy Ladah for plaintiff.
Judge Chu for the plan.
Stephanie Zinna, Paterno Girani for Zaon Collins.
Mr. Johnson, you want to unmute yourself? He responded, right?
He did.
Oh, he responded to you?
Yeah, I'll get him right now too.
Mr. Johnson, can you just say your name for the record and who you represent?
Sure. Sorry, Your Honor. Brad Johnson, on behalf of Mr. Collins.
Okay, so the question we got is how many jurors must agree on the answer to a question for the majority to rule in providing an answer? Signed, floor person. So I think what this asks for, and we can't go through and pick it, but I think, and nitpick it, I think they're concerned about each individual question as they go through. So our inclination when we get a question like this is simply to refer them to the instructions that say the 6 out of 8. But do counsel have any problem with me saying that exactly, which we write another note to them that said, please refer to the instructions. And I think maybe it might be a good idea for us to actually give them the number of the instruction if anybody doesn't have a problem with it, which it is instruction number. Instruction number 45, the last paragraph says, in civil actions, 3/4 of the total number of jurors may find and return a verdict. This is a civil action. As soon as 6 or more of you have agreed upon a verdict, you shall have it signed and dated by your foreperson and then return it to this room. So I'm inclined to say, please refer to instruction number 45.
Plaintiff has no objection to doing that, Your Honor.
No objection.
Mr. Johnson,
No objection, Your Honor.
so can you just type another statement that says, please, in response to your question, please refer to instruction number 45. Signed, Judge Albertson. And again, once she prints it, I'll show it to you both, so you know exactly what's gonna go back to them.
Is she gonna put 2 floor person on the note? Just kidding. Just
Is
joking.
it floor like FLOOR?
You are welcome to come up and read it.
FLORE.
I kind of want to see
I'm
it.
just curious. ORE.
We have to understand that this is like an everyday thing for
It
us,
is,
but it is
yeah.
not for everybody
I
else.
love that.
It is true.
It makes sense though, because they would be like the supervisor.
And if you work at a casino in town, it is called floor person a lot of times.
It actually kind of makes sense.
You want instruction number 45 or juror?
Just instruction number, or juror instruction number 45, that's probably fine. So yeah, I don't think it's that out of the norm.
No, I think I actually kind of like the leap there.
Thanks.
Like that?
Anybody have a problem with that?
I'm sorry, can I have him look?
Sure.
No objection.
And 45 does have the exact paragraph that I read into the record a minute ago. Okay,
Thank you.
thank you. Thanks.
Thank you.
Thanks, counsel. We will contact you if anything else comes about. And if you want to stay nearby, you're welcome to as well.
Thank you.
We're back on the record in case A 21844652C. Anna Marie Echevarria versus Zaon Collins. So I have 2 questions from the jury. The first one, can we agree to majority rules if 5 vote one way and 3 vote the other way? Signed, foreperson. Can we answer all questions in the special verdict form? Do we all come back to court tomorrow? Question mark, signed, foreperson.
Can you read the second one again, Judge? I know you have to read it
Yeah,
how
why
it's
don't you
written.
come up and read them?
Thank you.
Yeah.
Sounded like a
And I will start drafting.
Question and a half there.
Yeah, they are.
Oh, they were 4%.
Yes, I think because instruction that we referenced before actually says 4-person. So I was curious.
Oh,
if that
once
was
we
gonna
answer all questions, it's where from. We all come back to court tomorrow.
Okay, so, no. And,
Well,
I mean,
how are we really gonna?
yeah, I don't know,
Okay, why
right?
don't you guys back up?
Yeah.
If you want, does anybody want to see another copy or do you guys feel like you've seen them?
Oh, okay.
Okay, so let's figure out a response. So the first one, once we answer all questions in the special verdict form, do we all come back to court tomorrow? 4-person. Now, there is a punitive phase of this, so I think the answer is probably, it depends.
Yeah.
Okay, I hate to say that to them, but that's really the answer that I'm thinking of is honest and correct, but does somebody have another response?
I don't think we can answer that question, Your Honor, because if we answer it honestly, I think we discourage them from taking their time to and objectively answering the last question.
yeah, it may very well influence their decision on the last question.
From my perspective, I don't think that they've shown an unwillingness to take their time at this point.
And we don't have an issue until the 23rd.
Right.
As far as I remember. And I have the only thing I have on tomorrow is a settlement conference, which I can do in his courtroom if I need to. Or I can reschedule if they're ready to go and we're ready to do the punitive portion of this case.
And so, I mean, from my perspective, I think we need to give them a little bit more information. Then it depends. I don't know if we can get to something that we can agree to, but I think it depends. It is just going to unnecessarily confuse them.
Okay, let's go back to it in just a second. What about, can we agree to majority rules if 5 vote one way and 3 vote the other way? My response to that one is no.
I would agree, Your Honor. Obviously, that would violate the law.
I think that's exactly what one of them doesn't want me to say, but, so. My clerk is suggesting to once we answer all questions in the special verdict form, do we all come back to court tomorrow? In response to your question, your return depends on the answers provided in the special verdict form. But I think that's the same concern that you have, right, counsel?
Yes, Your Honor, we're concerned about that answer because we think that signals to them that if they answer no on the last question, they don't have to come back, which encourages them to answer no.
And I think that's vague enough to satisfy the concern as well as, with how careful and.
It
Consider
depends
they're
on your
already-
answers.
Right, so instead of saying, if you check yes or no on a punitive box, if you say no, you don't have to come back tomorrow, I think that would be prejudicial. But just leaving it as vague as your Madam Clerk just put it, I think that gives them an answer without incurring the prejudice of more information as to which box it would be. And again, I don't think that there is a concern given how careful and thoughtful this jury has already shown themselves to be.
Well, here's another problem too, and this is why I'm not sure. And this is why I just kind of want to say it depends and leave it at that. Because if we poll them and if only 4 of them say this is their verdict, they also go back there and continue to deliberate. Okay, so, once we answer all questions in the special verdict form, do we all come back to count tomorrow? I think my response to that probably is I can't answer that at this time. Because, or do we all come back to court tomorrow? If I say I can't answer that at this time, because depending on their answer, depending on what they respond, I assume that both sides, well, maybe depending on the verdict, one side or the other is gonna want them polled. Am I wrong about that?
I think that's fair.
Okay, so if I was to say, once we answer all questions in this special verdict form, do we all come back tomorrow? I can't answer that at this time. Anybody have a problem with that response?
No, Your Honor.
I don't have an objection to that response.
What font were you using? 'Cause I want it to match so they don't think that I was answering them before and now I'm not answering them, or,
What if it, I have another suggestion, Your Honor.
okay, what's the suggestion?
What if instead we said, I'm not permitted to answer that at this time?
Our concern, Judge, is that you say I can't answer that at this time. It's just kind of signaling a more subtle version of the same concern we have, which is, well, the judge can't answer it until she sees what our response is on this last question. Or if you say you're not permitted to, then it implies it's more of a procedural process.
So what do you want me to say instead? I'm sorry that,
I'm not permitted to answer that at this time.
Instead of
But
saying
you
I
are
can't.
permitted to answer it, Your Honor, so I object to that. I like
Yeah,
what we had before.
Join that as well. I think the language you had is fine.
I'm sorry, Cabrio, which size, 12? 20, and were you bolding it or no? Okay, so as to the question about once you answer all questions in the special verdict form, do you have to return tomorrow? I cannot answer that at this time. As to the question about can you agree majority rules if 5 vote one way and 3 vote the other way? No.
Would you, and maybe refer them to the same jury instruction?
I can say, please see the instructions. I didn't want to be. I can say, please see the instructions. Does anybody have a problem with me saying, please see instructions?
No, that's fine.
No, I don't have a problem.
The same instruction as we referred them to last time.
No, she's.
And that was instruction 45. Okay, so let me print this. We might be reaching the record, by the way, of the most sure questions we've had so far in this courtroom.
That's what we were just saying.
I've never seen it in any of my trials, Your Honor.
Okay, come on up. We do actually get a lot of questions in here, but I don't think we've ever had this many. We usually just get like 1 or 2 from a jury.
I've seen one numerous times, never seen. Yeah, I'm good with it.
Okay, so that's what we will return to them. Okay. What'd you say, Kim? Yeah, thanks. Okay, does anyone else want to make any record at this time? Mr. Ladah,
Not complaining, Your Honor.
Ms. Zinna,
No, Your Honor, thank you.
Mr. Johnson.
No, Your Honor, thank you.
And I wasn't trying to, Mr. Chu and Mr. Ronnie, you're obviously welcome to say anything you'd like as well.
In that case, Judge.
Okay, thank you guys very much. We will contact you if anything else comes up.
Thank you.
Before they come in, I'll just let council know I do this part as fast as I can. And I get to reading as fast as I can too, because I know how it felt to be in either of your shoes. And this was the part that made me the most nervous when I would watch the verdict go through. And I remember thinking, can I see it? Can I see it? What does it say? Which one did they fill out? So I do this part as fast as I can, but there are stuff that I have, there are things that I have to do and I have to read before it can be read aloud. So it's not in any effort to delay this process. Council know, but I'm looking at you because you're not counsel, but it's not never any effort to delay, but it does take a moment before it gets released.
Judge, they still have to go across the street to jury services afterwards.
Well, depending on what they fill out,
Oh, you're right.
um,
You're right.
they might just be taking a 15-20 minute break.
Is reverse karmic energy.
That's a very good question.
That's what we realized.
Didn't realize how late it was already. Before they walk in, if we do move to the second phase, how long do you anticipate your part being?
Not long, Your Honor, but we would request that we have the evening.
Well, I'm not sure we can do this today, is why I'm asking, unless you think it's gonna be like 5 minutes or less, and I imagine you have questions too, right?
I do.
Do you have any idea? Is your part gonna depend on how long their part
Very
is?
short. Yeah, but it would be very short regardless.
See what we get through.
I mean, short, Judge, I'd say give or take 30 minutes though.
Okay. So the record's clear. When I ask if anybody wants to pull, I'll ask plaintiff first and then I'll ask defendant. Okay, and I can even ask if I don't get a yes at some point, I will ask all three of you separately. So, Mr. Johnson, you're not waiving your response. I'll ask you specifically too.
Thank you, Your Honor.
Thank you. If everybody could please be seated. Do the parties stipulate to the presence of the jury?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Has the jury elected a foreperson? Okay, and who is a foreperson? Okay. Ms. Foreperson, have at least 6 of the 8 jurors agreed on a verdict? Okay, please give the verdict form to my marshal. The clerk will now read the verdict out loud.
District Court, Clark County, Nevada. Anne Marie Echevarria, an administrator of the estate of Eric Echevarria, Anne Marie Echevarria, an heir of the decedent Eric Echevarria, and also guardian ad litem of minor Eric Jason Echevarria Jr., heir of the descendant, versus Zaon Collins, Marvin Collins, Does II through XX, inclusive in Rose businesses entitled 1 through XX inclusive. Case number A-25-844-652-C, Department number 11, Special Verdict Form. We, the jury, return the following verdict. Liability. Do you find, by the preponderance of the evidence, that Zaon Collins was negligent? Answer, yes. Do you find, by a preponderance of the evidence, that Zaon Collins' negligence was the legal cause of Eric Echevarria Sr.'s death? Answer, yes. Do you find, by a preponderance of the evidence, that Eric Echevarria Sr. was negligent? Answer, no. If you answered no to question 3 above, then skip question 4 and 5 below and proceed to answer question 6 below. If you answered yes to question 3 above, then proceed to answer question 4 below. Damages. Answer question 6. What amount of damages do you award Anne Marie Echevarria and Eric Echevarria Jr.? A. Plaintiff Anne Marie Echevarria's grief, sorrow, loss of probable support, loss of companionship, society, comfort, and consortium, and damage for pain, suffering, disfigurement, and loss of enjoyment of life of the decedent from the date of the incident to present, $3,722,963.27. Plaintiff Anne Marie Echevarria's grief, sorrow, loss of probable support, loss of companionship, society, comfort, and consortium that she is reasonably certain to experience in the future, $3,722,963.27. Plaintiff Eric Echevarria Jr.'s grief, sorrow, loss of probable support, loss of companionship, society, and comfort, and damages for pain, suffering, disfigurement, and loss of enjoyment of life of the decedent from the date of incident to present, $3,722,963.27. Plaintiff Eric Echevarria Jr.'s grief, sorrow, loss of probable support, loss of companionship, society, and comfort that he is reasonably certain to experience in the future, $3,722,963.27. Damages for Eric Echevarria Sr.'s medical expenses, $99,008.91. Damages for Eric Echevarria Sr.'s funeral expenses, $9,138. Total damages for Anne Marie Echevarria and Eric Echevarria, calculated by adding categories A through F above, $15 million. Does the jury find by clear and convincing evidence that punitive damages should be assessed against defendant Zaon Collins on behalf of the estate of Eric Echevarria Sr.? Answer, no. Dated this 20th day of May, signed by the foreperson. After the verdict form has been signed, please return it to the court.
Okay. Can I have it back, please? Plaintiff's counsel, do you desire to have the jury pulled?
Yes, Your Honor.
I'm just gonna keep asking. We are gonna pull them because of that answer. Defense counsel Zinna, do you desire to have the jury pulled?
Yes, Your Honor.
Defense counsel Johnson, do you desire to have the jury pulled?
Yes, Your Honor.
Kim, can you please pull the jury? What?
I would be happy to.
Thank you.
Juror number 1, are these your verdicts as read? Juror number 2, are these your verdicts as read?
Yes.
Juror number 3, are these your verdicts as read? Juror number 4, are these your verdicts as read? Juror number 5, are these your verdicts as read? Juror number 6, are these your verdicts as read? Juror number 7, are these your verdicts as read?
Yes.
Juror number 8, are these your verdicts as read?
Okay, give me just one moment. I'm just making sure there's no math mistake here. Okay, ladies and gentlemen, as you know, the right to trial by jury is one of our basic and fundamental constitutional guarantees. I firmly believe in this right. That's the right of every litigant in a civil case to be judged by a fair and impartial jury. You must have jurors, and unfortunately, juror service is something many people shirk from. They don't want to become involved. That's why, on behalf of everybody and on behalf of the 8th Judicial District Court, I thank you so much for being willing to give your valuable time. You've been most attentive and conscientious throughout this trial. We've actually talked about the amount of questions we got and how much it seemed that everybody was paying attention throughout this case. So thank you very much for your time and attention. On behalf of the attorneys, the parties in the 8th Judicial Court, we wish to thank you for your careful deliberation, which you gave to this case. The questions may arise at this time, or you may wonder whether you're now able to talk to people regarding this matter. And my response to that is, if you wish to talk to people about this matter now, you are free to talk to whoever you want to about this case. However, you are not required to talk to anybody about this case. Okay. I will be available to speak with you if you would like to speak with me. If anybody wants to speak with me or wants to speak with me privately, you can head back to the jury deliberation room and I will head in there and talk to you privately if you would like. If anybody would like to speak with any of the counsel, I can speak for counsel here, where they probably would be very welcome to that communication. And if you want to do that again, like I said, head back to the jury room and just let me know that you'd like to do that. And I'm sure the counsel would be happy to come back and talk to you if you have any questions or if you want to talk to them about anything. I will tell you, as somebody who sat for years and did trial work, it is very helpful when jurors tell you or give you feedback or are willing to give you feedback. But we also understand your time is valuable and maybe you don't want to do that and you are not required to do that at any time, either now or later in the future. Okay. At this point, If anybody does proceed to talk to you about this case and you do not want to talk to them, you can let my marshal know or me know. If you need our contact number for this courtroom, please get it from the marshal on your way out. If anybody needs a note for work or anything else, again, please get it from the marshal on your way out. If anybody does want to talk to me though, like I said, just go ahead and head back to the deliberation room and I'll be there in just a couple minutes. So with that being said, you are excused. We do thank you. If anybody's back in that room, I'll be back there in a couple minutes to talk to you. And if you want to talk to any of the council, just let me know when I get there that you do want to talk to some of the council, and I'm sure they'll be willing to talk to you as well. So thank you very much, ladies and gentlemen. You are free to leave if you would like to leave at this time.
Advise?
At this time, does any attorney wish to make any kind of record?
Not from plaintiff, Your Honor.
No, you're.
Mr. Johnson?
No, Your Honor.
Then we are going to go off as well. If anybody would like a picture of the verdict form, you can come up and take a picture of it, but we will file it as soon as we can as well. Okay, I'm going to head back to find out if any of them have gone into the deliberation room, and I will come out and let you know if any of them have. And if you are willing to wait around to see if any of them want to talk to you, that might be a nice thing to do if you're willing to do so. Okay, thank you very much, counsel. Have a
Thank
good
you.
night.
Judge, can I take a picture?